and the Civil War amendments, Amendments 13, 14, and 15. And the guest is Dr. Julian Blackshear, who has given us some information relative to the Constitution as well as the 13th Amendment to the Constitution. And of course, Dr. Blackshear, let's have you to continue your discussion in reference to these three amendments.
Well, before the break, I was trying to emphasize the point that the 13th Amendment that abolishes slavery abolishes the characteristics of being a slave as well. And one of the characteristics of a slave is lacking the ability to make or engage in contracts on the same terms available to all citizens of this country. So the 13th Amendment abolishes. So if black people are prevented from entering into negotiations with various racially exclusive emissions policies of white businesses and so forth, they are still, that's violation of the 13th Amendment.
That denies the right to make contracts.
Right, it denies them the right to make contracts, which means that they're not really free, because that's the characteristic of a freeman. And the specific statute that you would file a lawsuit on to prevent such a conduct would be Title 42, United States Code, Section 1981, which is frequently used in employment discrimination cases. Now, the 14th Amendment, if you listen to the wording when it says, no state shall deprive a person of life, liberty, or property without due process of law, or deny unto them equal protection of the laws, it is saying, for our purposes today, that the government cannot engage in private discriminatory conduct, but it's also saying the government cannot even get involved in it. So, but before the 14th Amendment becomes applicable, there must be, as we call it, some state action, some state involvement, some state connection with the private activity in order for the 14th Amendment to apply to prohibit it. So we come up with three approaches to make sure that that occurs. The most common approach used is the agency approach. In the old case of Shelley versus Kramer is a good example of the racially exclusive racially restrictive covenants, where you have these deeds that would say that you can't sell this property to members of African ancestry. Well, in Shelley versus Kramer, a person violated that deed and made an attempt to sell the property. Well, the government, through its third branch of government, which is the government of Missouri, through its third branch, which is the court, enforced that deed because it is a contract. But enforcing that deed, the government got involved in discriminatory conduct. And once that happened, the 14th Amendment now becomes applicable, and it prohibited the whole thing. So you can have racially restricted covenants and deeds all over the place, but there's no court that can enforce it, because then the government, through the courts, will be involved in that discriminatory conduct. And so now we have satisfied the requirement of state action, state involvement, sufficient for the 14th Amendment to apply and prohibit it. The other approach is the encouragement approach. The old case of Reitman versus Mulkey in 1968, where you go through an initiative referendum to amend your constitutions in California. You had this person that submitted a petition to amend the Constitution by forbidding municipalities from passing any fair housing laws. Now, what that means is, once the Constitution is amended to say that, and it was amended to say that, then cities are no longer able to pass laws prohibiting racial discrimination in housing.
So now engaged in discrimination itself in real sense.
Well, it's not. It's what it's doing is encouraging people who may be inclined to discriminate to do so, because they know the cities no longer have their power to pass any laws prohibiting it. You see? So that's the encouragement approach. The states have gotten involved in it. Then the old case of Wilmington, Burton versus Wilmington Parking Authority. That's taking the agency approach again. What we got here now is like the Nashville Housing Authority. You got a lease arrangement where the Wilmington Parking Authority is a landlord, and then you got this cafeteria in the airport. There was a tenant. Well, this cafeteria excluded black people from going in there. And in doing so, the government is now involved in that prior discrimination because the government was the landlord of the facility where prior discrimination was being practiced in. So the 14th Amendment now can become involved and prohibit that kind of conduct. Now the third approach is the public function approach. It's just simply saying public accommodation facilities that open their doors to the public cannot cherry pick and determine which member of the public they can admit, because black folks are members of the public too. So that's one reason why, if you take the public function approach, the 14th Amendment will prohibit that kind of conduct, because black people are just as much a part of the public as anyone else that these businesses are established specifically to serve. Not to serve some members of the public, not private clubs, but public accommodations like Crystals, like McDonald's, like Wendy's. They're open specifically for the purpose of serving the public. Now, and then you cannot say black folks are not a part of the public, but when you try to exclude people from being a part of the public, then the 14th Amendment, the government is involved in that. And then the 14th Amendment is invoked to prohibit such conduct.
And so in reality, it's much greater than citizenship as such. Well, how is it that we
the 14th Amendment, they say that in 8th grade history, 14th Amendment is designed to make you a citizen, but the 14th Amendment prohibits the 14th Amendment guarantees that black people shall be treated equally under the law. And in so making that guarantee, obviously, you're a citizen. See, that's how that works.
Is that how that,
but the best way to teach it is, rather than the simplistic notion that the 14th Amendment makes you a citizen, you just simply say the 14th Amendment guarantees that black people shall be treated equally under the law with everybody else. It prohibits discrimination. So if a black person is not a citizen, then you're being discriminated against in favor of other people who are made citizens. So when you grant people equal protection of the law, one of the benefits of that is citizenship. But there are 1,000 other benefits of that, you see.
Well, now, would you not say, over the last 35 seconds that we have here, and then this will sort of get you into 14th and 15th Amendment, that the very fact, this is something we might say in reference to that very fact that you've outlined all of these characteristics of the 14th Amendment. What about when Africans first came out of slavery in 1865, and there was no statement in reference to their citizenship or their rights and etc.? Would this not be just a sort of a bridge to try to bring that in, bring citizenship in? That is to teach that.
The 14th Amendment does make you a citizen.
And of course, let us take this short commercial break, and we'll be back with our audience following this very short break. We're talking to Dr. Julian Blackshear.